The idea that a convicted person, someone who has broken the law and faced justice, could somehow slip through the cracks and end up holding one of the most powerful offices in the country, like a senator, sounds like something out of a movie. It's a gripping thought, full of intrigue and a deep-seated suspicion that the system isn't always fair or logical. The question, did a legal loophole make a convicted man a senator? Matt Ward hits on all these feelings. It brings up questions about justice, the fairness of our laws, and whether people can truly escape their past actions, especially when it comes to public trust. This isn't just a simple yes or no question. It's much more complicated than that, and it touches on some fundamental parts of how our government and legal system work, or how people perceive them to work. When people ask about a legal loophole, they're usually imagining some clever trick, a hidden pathway in the law that lawyers discover, allowing someone to do something that seems wrong or goes against the obvious intention of the rules. It suggests that the law isn't a perfect solid wall, but more like an old fence with some loose boards or holes you can crawl through. And if that loophole could let a convicted person, someone like our hypothetical Matt Ward, become a senator, it would feel like a betrayal of public trust. It would make people question everything. We naturally tend to look for stories like this, for examples where the system is gamed, or where a person, despite their past, achieves something incredible or scandalous. This isn't because we necessarily want to believe the worst, but because it challenges our understanding of how things should be. We expect people in high office to be beyond reproach, or at least to have cleared their names completely. The idea of a convicted person becoming a senator, especially through a loophole, feels like a fundamental violation of that expectation. It speaks to a common public cynicism about politics, a feeling that those in power sometimes operate by different rules or find ways around the rules that apply to everyone else. The name Matt Ward in this question works as a stand-in, a kind of everyman or every politician figure for this specific scenario. It doesn't point to a specific real person who definitively did this, but it focuses the question on a tangible, relatable figure. It allows us to explore the legal and political landscape as if it were about a real case. This makes the discussion less abstract and more immediate. We can imagine Matt Ward, imagine his past conviction, and then try to see how he might navigate the complex web of laws, qualifications, and public opinion to reach such a high office. To understand if such a thing is even remotely possible, we need to break down a few key concepts. First, what exactly constitutes a conviction in the eyes of the law, especially when it comes to eligibility for office? Is it just any conviction or only certain types? Second, what are the actual requirements for becoming a senator in the United States? These aren't just vague guidelines, they are specific constitutional and legal mandates. And third, what is a legal loophole in practice? Is it truly a hidden escape clause? Or is it more often a matter of interpretation, or perhaps the way different laws interact in unexpected ways? The weight of this question isn't just about technical legalities, it's also about the spirit of the law, about what society expects from its leaders, and about the moral and ethical implications of allowing someone with a criminal record into a position of immense power. A senator is not just a lawmaker, they are a representative, a symbol of their state, and, in many ways, a guardian of the nation's principles. The very suggestion that a legal technicality could override serious past transgressions for such a role is unsettling to many. It suggests a potential flaw at the very foundation of our representative democracy. So let's carefully pull apart these threads and see what we find when we examine the rules, the interpretations, and the slim chances, if any, for someone like a convicted Matt Ward to become a United States Senator. To even begin thinking about whether a loophole could allow a convicted person, like our Matt Ward, to become a senator, we first need to understand the basic rules. What does it take to be a U.S. senator? The requirements are actually pretty few, and they're laid out right in the U.S. Constitution in Article 1, Section 3. To be a senator, you need to be at least 30 years old, have been a U.S. citizen for at least 9 years, and when elected, be an inhabitant of the state you represent. That's it. Notice what's missing there. Any mention of criminal record or past convictions. This absence is crucial because it often forms the basis for arguments about who can or cannot hold federal office. But just because the Constitution doesn't explicitly mention criminal records doesn't mean they're irrelevant. Other laws, both federal and state, and the historical practices of Congress itself come into play. Generally, when we talk about a conviction disqualifying someone from public office, we're usually talking about felonies. A felony is a serious crime, more serious than a misdemeanor, and it typically involves a possible sentence of more than a year in prison. States vary on exactly which crimes are felonies, but they usually include things like murder, assault, robbery, major fraud, and so on. The ability of a convicted felon to hold office, or even to vote, is often tied to what's called felon disenfranchisement. This refers to laws that restrict the voting rights and often the civil rights of people with felony convictions. These laws vary wildly from state to state. Some states automatically restore voting rights upon release from prison, while others require completion of parole, probation, or even a separate application process, or they might permanently bar certain felons from voting. And if you can't vote, you usually can't hold office either, especially at the state or local level. However, the question here is specifically about a U.S. senator, which is a federal office. For federal offices, the rules are often seen through a slightly different lens. The Supreme Court has historically said that Congress can't add new qualifications to those listed in the Constitution. This means that Congress can't simply pass a law saying, no felons can be senators. If they did, it would likely be struck down as unconstitutional because it adds a qualification not found in Article Y. This is a very important point for understanding any potential loophole. Despite this, there are indirect ways convictions can matter. For instance, if a state's laws permanently bar a convicted felon from voting, and voting is seen as a prerequisite for running for office in that state, then a person like Matt Ward might be effectively disqualified at the state level before they even get to the federal election. But even that is not always clear-cut when it comes to federal offices, because federal law generally governs federal elections even if administered by states. There are also specific federal laws that address certain types of crimes in relation to holding office. For example, some federal laws disqualify individuals from holding any office of honor, trust, or profit under the United States for specific offenses like treason or rebellion. Other laws target specific types of corruption. For instance, someone convicted of bribery might face additional penalties that prevent them from holding office. But these are usually specific statutes tied to specific, very serious federal crimes, and they aren't blanket bans on all felonies. Another crucial factor is the Senate itself. Article I, Section 5 of the Constitution states that each house shall be the judge of the elections, returns, and qualifications of its own members. This means that if Matt Ward were elected, even with a conviction, the Senate itself would have the power to decide if he meets the qualifications and if he should be seated. This power is significant. It means the Senate could theoretically choose to interpret the constitutional qualifications very strictly, or it could choose to consider other factors, including the nature of a past conviction. They could decide that even if a conviction doesn't technically violate the age, citizenship, or residency rules, it might make someone unfit to serve. This isn't adding a new qualification, it's judging whether an elected member is qualified under the existing framework, which can be a subtle but important distinction. So, while the direct constitutional qualifications are minimal, the practical reality of being elected and seated as a senator with a felony conviction is very different. State laws on felon disenfranchisement, specific federal disqualification statutes for certain crimes, and the Senate's inherent power to judge its members' qualifications all create a complex environment. It's not a clear-cut situation where a past conviction automatically means no office, but it's also not a free pass. The devil, as they say, is in the details, and the loophole idea would have to find its footing somewhere within these intricate layers of law and congressional power. This setup creates the perfect breeding ground for the idea that someone could find a way through the cracks, which brings us to the next part of the discussion where these supposed loopholes might actually exist. Now we get to the core of the question, the legal loophole. When people talk about a loophole, they usually mean one of three things. It could be an unintended omission in the law, where something was simply not covered. It could be ambiguous wording that allows for multiple interpretations, or it could be a very narrow, literal reading of the law that, while technically correct, goes against the obvious spirit or intent of the lawmakers. For someone like Matt Ward, a convicted man, to become a senator through such a mechanism, it would require a confluence of these elements, carefully exploited. Let's explore some areas where such a loophole might theoretically exist, keeping in mind that the bar is extremely high for a U.S. Senate seat. One potential area revolves around the type of conviction. Not all convictions are equal. If Matt Ward's conviction was for a minor misdemeanor, say a traffic violation or a very old, non-violent offense that was later expunged or sealed, the impact on his eligibility would be vastly different than if it were a major felony. Federal laws often focus on specific types of offenses, such as those involving treason, bribery, or election fraud, as directly disqualifying for federal office. If Matt Ward's conviction didn't fall into one of these specific federal disqualification categories, and it was a state-level crime, then the loophole might be that there isn't a federal law explicitly barring him. The constitutional qualifications, as we discussed, don't mention convictions. Another angle could be the timing of the conviction and the election. What if Matt Ward was convicted, served his time, and then years later his civil rights, including the right to vote and hold office, were automatically restored under state law? Many states have provisions for this, especially for nonviolent felonies after a certain period. In such a case, he wouldn't be exploiting a loophole so much as benefiting from the standard process of rights restoration. The loophole idea really comes into play if his rights weren't fully restored, but he still found a way to run and win. This leads to the power of a presidential pardon or commutation. A presidential pardon completely forgives a federal offense, wiping out the legal effects of the conviction and restoring full civil rights, including the right to vote and hold office. If Matt Ward had a federal conviction and received a full presidential pardon, he would legally be in the clear. He wouldn't be using a loophole in the sense of finding a gap, but rather using an established constitutional mechanism for clemency. The key here is a full pardon. A commutation just reduces a sentence but doesn't restore rights in the same way. So, if Matt Ward had a serious federal conviction that would normally disqualify him, a presidential pardon would be his clearest path. But this isn't really a loophole, it's a specific established power of the executive branch. What about ambiguity in the definition of conviction itself? Sometimes plea deals result in a no contest, plea nolo contendere, rather than an admission of guilt or a deferred adjudication where a conviction isn't formally entered if certain conditions are met. Or, what if an appeal is pending? Could Matt Ward argue that he isn't convicted until all appeals are exhausted? For a federal office, like a senator, the standard is usually fairly clear that once a jury or judge finds you guilty, or you plead guilty, and a judgment of conviction is entered, you are considered convicted regardless of appeals. This avenue for a loophole is typically very narrow. The most potent potential loophole often comes back to the Senate's power to judge its own members. As noted, the Constitution says the Senate can decide if a member is qualified. While they can't add new constitutional qualifications, they have a degree of discretion. If Matt Ward were elected with a conviction, the Senate could, in theory, decide to seat him, especially if his conviction didn't fall into the narrow category of crimes that federal law explicitly disqualifies people for, and if his civil rights have been restored. The argument would be that since the Constitution doesn't mention convictions as a disqualifier, and no specific federal statute applies, then he meets the constitutional requirements. The political reality, however, would be immense. Any decision to seat a convicted felon would spark a massive public outcry and a fierce debate within the Senate. This isn't a legal loophole as much as it's a political choice made under the umbrella of constitutional power, but with very real consequences. Another, less likely scenario could involve the jurisdiction of the conviction. Suppose Matt Ward was convicted of a serious felony in a foreign country. Would that automatically disqualify him from a U.S. Senate seat? While it would certainly make him politically toxic and raise immense questions about his suitability, the direct legal disqualification based solely on a foreign conviction is less clear-cut under U.S. law compared to a domestic one, especially if his U.S. civil rights remained intact. This is a very theoretical stretch, though, given the immense scrutiny any candidate for federal office faces. Ultimately, the idea of a loophole for a convicted person to become a senator isn't about some obscure hidden clause that completely contradicts the spirit of the law. It's more likely about how different layers of law, constitutional, federal statute, state statute interact, the precise nature of the conviction, the restoration of rights, and, crucially, the political will of the Senate itself. For Matt Ward to pull this off, he wouldn't just need a clever lawyer, he'd need an incredibly specific set of circumstances to align perfectly, and then he'd need to overcome an almost impossible political and public relations battle. The path, if one exists, would be narrow, fraught with peril, and certainly not something that would go unnoticed or unchallenged. While the specific scenario of a convicted Matt Ward becoming a senator via a clear loophole isn't something we can point to in history, looking at past cases gives us a lot of insight into how the system actually works when politicians face legal trouble. These historical moments show us the boundaries, the pressures, and the tools available when someone with a checkered past tries to hold or gain office. They help us understand why the Matt Ward loophole scenario is so unlikely, but also where the potential areas of friction and debate lie. One key thing to remember is that the requirements for holding office are often different from the requirements for running for office. States have a lot of power over who can appear on a ballot, and they often impose additional restrictions, like requiring candidates not to be currently serving a felony sentence. However, these state-level restrictions can sometimes be challenged when it comes to federal offices like the Senate, because of that Supreme Court ruling that Congress cannot add qualifications to those listed in the Constitution. This creates a tension that a hypothetical Matt Ward might try to exploit. There have been instances of individuals with past convictions, even serious ones, who have held public office, but almost always under very specific circumstances. Often, these were cases where the conviction was old, or it was for a crime that, while serious, didn't automatically disqualify them from office under existing laws. More importantly, many of these individuals had their civil rights fully restored, often through a pardon or through the passage of time under state law. For example, some politicians in the past who were convicted of crimes related to political protests or specific nonviolent offenses, and who later received pardons, have gone on to serve. But this isn't a loophole. It's a constitutional act of clemency. Consider the case of Representative James Traficant. He was convicted of 10 felony counts, including racketeering, bribery, and tax evasion, while in office. He was then expelled from the House of Representatives. This shows that while a conviction doesn't automatically remove you from Congress, he was convicted in April 2002 and expelled in July 2002, not immediately. Congress does have the power to judge its members' conduct and remove them. This isn't about pre-election qualification, but post-election fitness for office. It demonstrates the chamber's ultimate authority. If Matt Ward were to somehow get elected with a serious conviction, the Senate could take similar action. Another relevant area involves challenges to a candidate's qualifications before or immediately after an election. When a candidate's eligibility is questioned, it often goes through state election boards, or, if it involves federal office, can ultimately be decided by the House or Senate themselves. In these cases, the body examines whether the individual meets the constitutional and relevant statutory requirements. They look at age, citizenship, residency. If a conviction is brought up, the main question usually isn't, is a conviction a disqualification, but rather, does this conviction affect a constitutional requirement? Or is there a federal statute specific to this type of crime that applies? For example, there's a federal statute that prevents people convicted of sedition or rebellion from holding any federal office. If Matt Ward had been convicted of treason or insurrection, he would very clearly be disqualified under existing federal law, not because of a loophole, but because of a direct statutory bar. The loophole idea usually arises when the crime doesn't fit these very specific disqualifying categories, and the person's civil rights like voting have somehow been restored, leaving only the minimal constitutional requirements. Public opinion plays a massive, often unspoken role here. Even if a legal pathway exists, the political cost of electing or seating a convicted felon is immense. Voters tend to reject candidates with serious criminal records. Political opponents would undoubtedly make it the central issue of any campaign. Even if Matt Ward somehow won the election, the Senate itself, as the judge of the elections, returns, and qualifications of its own members, would face incredible pressure. Seating someone with a serious criminal conviction, even if no explicit federal law barred them, would be seen by many as a stain on the institution. It would take an extraordinary political will and a very unique set of circumstances for the Senate to choose to seat such a member, going against a strong public sentiment. So, while we might find examples of politicians who faced legal issues or even had convictions and still held office, they rarely involve a loophole in the sense of a trick to bypass clear disqualifications. Instead, they often involve one: crimes that weren't disqualifying under existing law. The historical record suggests that the federal system, particularly for a high office like senator, is designed with enough checks and balances, constitutional requirements, specific federal disqualification statutes for very serious offenses, and the Senate's own power to judge qualifications that a true loophole, allowing a convicted felon to effortlessly become a senator, is more of a persistent public fear than a documented reality. The path would be thorny, legally contested, and almost certainly politically suicidal. So, let's get straight to the point about Matt Ward and the idea of a legal loophole making him a senator after a conviction. The answer is, plainly, no, not in any known real-world case matching the specific and dramatic implications of the question. There is no historical example or documented instance where a convicted individual, particularly one with a significant felony, used a clever loophole to become a United States senator while their conviction remained an active, unmitigated disqualification in the public and legal eye. The reason for this now is a combination of the factors we've discussed. First, while the U.S. Constitution's requirements for a senator are minimal age, citizenship, residency, this doesn't create a wide open door for anyone with a criminal record. Federal law does have specific disqualifications for certain grave offenses like treason or rebellion. If Matt Ward's conviction fell into one of those categories, he'd be explicitly barred by statute, not just by public sentiment. Second, the concept of rights restoration is key. For most people with felony convictions, their civil rights, including the right to vote and hold office, are lost, at least temporarily. For Matt Ward to even get on a ballot, he would almost certainly need to have had his civil rights restored under state law. This often happens automatically after completing a sentence, probation, and parole, or sometimes through a specific application process. But a full restoration of rights isn't a loophole. It's a defined legal process designed to reintegrate individuals into society. If he had a federal conviction, a presidential pardon would serve the same function, restoring his legal standing completely. In either of these scenarios, he wouldn't be using a loophole to circumvent a conviction. He would be someone whose conviction's legal effects have been formally mitigated or erased. Third, and perhaps most crucially, is the Senate's power to judge its own members. If Matt Ward, even with restored rights, were to be elected with a serious felony conviction in his past, it would trigger an intense challenge to his seating in the Senate. Article I, Section 5, gives the Senate the authority to decide if its members meet the qualifications. While they can't add new constitutional qualifications, they can interpret the existing ones and judge the fitness of a member. A senator-elect with a significant conviction, even if no specific federal statute applies, would face immense political pressure and likely an internal Senate vote on whether to seat him. The political optics of seating a convicted felon would be catastrophic for the Senate as an institution, making it highly improbable they would do so, regardless of any narrow legal argument. The political costs would far outweigh any technical legal argument for seating him. The loophole implies a clever, almost sneaky circumvention of the spirit of the law. But in the context of federal office, especially the Senate, such a direct and public challenge would be almost impossible to manage. Where campaigns are brutal, and any past conviction would be thoroughly vetted and weaponized by opponents. The public would demand answers, and the media would scrutinize every detail. There's simply no hiding a past conviction, particularly for an office as prominent as a senator. The persistence of this question, the Matt Ward scenario, speaks to a deeper concern people have about the legal system and political transparency. It feeds into a narrative that politicians are somehow above the law or can manipulate it to their advantage. It taps into a distrust of institutions and a desire for accountability. The idea of a loophole allowing a convicted person into the Senate is unsettling because it suggests a fundamental weakness in the system that protects public trust. But in reality, the checks and balances, the explicit laws, the power of clemency, and the intense political scrutiny surrounding federal elections make such a scenario highly improbable to the point of being practically impossible. It would take an unprecedented combination of legal ambiguity, political will, and public tolerance that simply hasn't occurred. While laws can be complex and sometimes have unintended consequences, the path to the Senate is too heavily guarded by both explicit legal requirements and the overwhelming force of public and political expectation to allow a convicted individual to slip in unnoticed or unchallenged through a simple loophole. The system, for all its imperfections, has layers of protection against such an outcome.